All right, welcome to the Baylor Law Executive LLM and Litigation Management monthly webinar. We're thankful for everyone who has chosen to attend this month's webinar, where we talk about bringing project management principles to the handling of the unmanageable litigation. You know, at Baylor and in the LLM program, we've developed a framework for the effective and efficient management of litigation. And in that framework, we call it R6. And what it really means, if I was going to say it in one sentence, it means that effective and efficient management of litigation is about doing things the right way, with the right plan, using the right team or the right people, doing it at the right cost, using the right tools, all of which to achieve the right result. Well, bringing project management, legal project management, to the area of litigation sort of permeates all of those different pillars. It's a very real and significant part of managing litigation effectively and enabling you to manage litigation efficiently. So to bring that topic to us today and to talk about it, I'm not going to be doing a whole lot of talking because, quite frankly, we've brought experts in the field. We welcome two fine shareholders from the Baker Donaldson firm. First, we have Jennifer Cooper. Jennifer concentrates her practice in the tort defense and business litigation. She chairs the firm's complex torts group. She's been national coordinating counsel, I think I read, for the world's largest claims servicing company. But she also helps clients and her firm use project management. She uses it within the firm, but also helps clients in the development of their own internal legal project management approaches. Her partner, her co-shareholder, David Roof, is also joining us. And I got to tell you that for those of you that don't know, we use David and Susan Raridan Lambreth's textbook on litigation management as part of, or legal project management as part of, the Baylor LLM program. And David is the Chief Solutions Group Officer, and he's responsible for the oversight and innovation and the use of project management across Baker Donaldson. And in fact, some of the things that David and Jennifer are going to share were actually developed by David and others for Baker Donaldson to be able to manage litigation more effectively using project management. With that introduction, and I could go on and on and on about both of them, but with that introduction, I'm largely going to turn this over to David and to Jennifer. I may interject, I'll monitor the chat feature, but to talk to us and share with us about this project management, legal project management in the litigation context, and how Baker Donaldson has implemented it in that firm. Thank you both for being here, and we look forward to the discussion that we're going to have. Go ahead, David.
Great. Thanks, Kyle. Let me share my screen here. All right. Can you see my screen?
Can.
All right. Let me move forward.
There we go.
Got it?
Yep.
All right. So I want to just give you a quick overview of what we're going to try to cover today. Thank you, Kyle, for the great introductions. Very flattered. We're going to first talk about, and this is primarily Jennifer, we're going to talk about historical attempts to control litigation costs. And Jennifer's going to speak from years of experience of trying to tackle that problem. We're then going to talk about how you can combine that type of portfolio experience with legal project management to really control costs and we believe improve the function of the team and improve the value for the client. We're then going to talk about how this whole concept of project management actually creates an atmosphere where you can capture more data to help your team be more efficient, and also to help you communicate more about what you're doing in the engagement. And then we're going to follow up with some conclusions and results. So with that, I'm going to turn it over to Jennifer to talk about historical litigation controls.
Thank you, David. So I'm sure that most of you attending today are familiar with these different historical attempts to control litigation costs. most of them have failed, or if they haven't failed, they haven't really significantly moved the needle, which is why the legal industry has continued to struggle with an effective way to manage costs. And by manage, that means not only reduce costs, but also to set reasonable expectations so that companies can properly budget for outside counsel in the management of their litigation. So some of the things that we've done in the past have included discounted rates, but typically they have no hourly controls on them. So the discounted rate is really meaningless unless you have a way of controlling the amount of time that's put into it. Unreconciled budgets. We all know about the clients that have asked us to put together budgets, and you send them to the client, and they go into a drawer and they collect dust, and nobody ever looks at it again until somebody gets upset about how expensive the litigation has become. And by then it's outdated and useless. Outside counsel guidelines, attempt to impose behavior on outside counsel and handling cases, and has not been particularly effective. ABA task and phase codes have been helpful. They've been helpful to us on the project management side because it actually helps us figure out and plan for future projects, but it hasn't necessarily moved the needle on legal spend. E-billing vendors have actually just created another layer of cost. They don't tend to be very effective, and they erode the confidence or the trust between the clients and the attorneys. Administratively burdensome write-offs and appeals. We've all been down that road, I'm sure, to some degree. They end up just being a lot like the e-billing vendors themselves. They just create more work and another layer of effort that just increases costs on both sides of the fence. E-discovery and document review vendors, they're in recent years, people have started outsourcing, firms and clients have started outsourcing this work. That has had some positive impact on the cost and the management budgets for large litigation matters. Outsourcing legal research and factual due diligence, there's kind of been mixed results with that. And then the reverse auctions, which actually are nothing more than a race to the bottom of the lowest possible fee arrangement with the quote unquote winning firm. So a better approach we have found has been to find a way to actually manage the strategy and the oversight by lawyers who have portfolio management experience. Clearly defined workflows for onboarding a case and reporting on the case throughout the life of the case is one method for doing this. Project planning and strict budgeting is implemented. Scope, assumptions, and out of scope, which means to clearly define what the scope of the engagement is, to be clear on both sides as to what the assumptions are about the legal services that will be delivered, and to be equally as clear as to what is out of scope. So this allows you to put together a more realistic budget and to plan the project in accordance with that scope and those assumptions. Optimal resource allocation. Once you have established a scope and the assumptions, then you can more adequately and precisely assign resources and allocate them amongst the various tasks in the litigation. And time guidelines for completing tasks that keep people on track and keep the case moving forward. It's the case that goes dormant for a while always becomes a much more expensive case. So we have found this project planning and strict budgeting helps to keep guardrails around the litigation, keep it moving forward in the most effective and efficient manner possible, and that helps to obviously manage the cost. Case management platforms that allow the stakeholders and the people involved in the litigation to share information, track matter progress, and enhance reporting to the client. Engaging the client with the platform that is developed to share information and continuously improve the process, because this allows for the client to give feedback as to what is and is not working, and it keeps the process evolving as necessary for the engagement or for the case. However, there may be cases in a portfolio that are not always amenable to the process because of the unique nature of the litigation. So it's important to remember that while large portfolios of litigation generally can be, and most often can be, effectively managed with project management, you will from time to time have the case that doesn't really quite fit the box. And so that will often require, you know, a unique development of a unique process and management program for that particular case.
Okay, so how do you get a legal team to work consistently in this approach that Jennifer talked about? One of the things that we've learned in our implementation of different approaches at Baker Donaldson is that you really have to have a consistent process, and then you've got to support that process with technology. So early on, we identified that we needed to invest in legal project management and pull together process and technology to help our attorneys and teams, you know, better manage the litigation that they are assigned. I guess the first question is, how did we figure this out? How did we identify that project management was a vehicle for helping us to achieve this objective? And so I'm going to share just a quick story with you of how we identified that project management was something we needed to look at. So in 2005, when Hurricane Katrina hit the Southeast region, Baker Donaldson was one of the firms that worked with several states on the administration of disaster recovery funds to help victims recover from the storm. And one of the areas of recovery specifically was a housing program that we supported. And in those housing programs, states are provided an allocation of federal dollars that they're required to distribute to eligible applicants, but there's a cap on the amount that a state can spend for administration. So what you see happening in many states is they put together a project management office, they assemble a team of professionals to help them through the life cycle of a recovery grant evaluation. That's an eligibility, you know, confirming the amount that an individual should get, you know, doing all the legal documentation of the entitlement to that grant, distribution of the grant, and then compliance. So we were part of a multidisciplinary team that was assisting the state of Mississippi with the administration of one of these programs. And they essentially created an assembly line process. Well, what they required each member of the team or each piece of that life cycle to do was to design their process, identify the team that they were going to utilize to facilitate that process, develop a monthly budget because the state wanted to make sure they operated within that administrative cap. And then we were required to operate pursuant to that process and meet production goals. Very big tasks for lawyers who were used to pretty much doing what they, you know, reacting and operating as the needs of the engagement required. The team also was required to implement technology so that we could, you know, manage our process and share information. So the one thing, and I was part of this project for Baker Donaldson, and one of the things that I learned was that if we went through that process, as time consuming as it was for a project that large, what happened is I would present my process, my budget, my estimates to the client. They would get confidence in me. They would trust that I had everything covered, and they would pay the bill. That was totally different than any other engagement that I had been involved with to that time, where you had clients not really understanding why we were doing what we were doing, and essentially, you know, not having full transparency. So that process that I was exposed to when the project was done, I came back to the firm and I said, this is something that I want to start doing in my own practice on a regular basis. I just liked the result, the collaboration with the client, and then not having all these billing surprises and billing disputes. And at the time, the firm was also looking at write-offs and write-downs and wanted a better process for us to be able to get better controls of those things. That's one of the things Jennifer pointed out as one of the challenges. So in 2010, we decided to develop our own project management process. We recognized that lawyers were not trained in this, and so we needed a repeatable process that we could ask our lawyers to follow. We also recognized, after implementing a couple of pilot projects, that technology, just like in the disaster recovery space, would greatly help us facilitate this process and make sure that all team members were engaged, were following the steps that we wanted them to follow so that we could control the costs, and then also give us a way to share information within the firm. So we developed this Baker Manage process, which is portrayed here. It basically has 3 phases: a development phase, where we're actually doing a better job of analyzing the case and developing a plan for it; an execution stage, where we're implementing tools to help our lawyers oversee the engagement; and then a closure phase, where we're doing something that lawyers never do, which is actually do a retrospective about what we did well and what we could improve upon. The difference between what we're doing in Baker Manage and what you see with other tools like Trello or Slack or Smartsheet is that we're implementing a process and technology that is sensitive to the needs of legal engagements. It's simple, it's secure, and let me highlight, it's got to be simple to get lawyers to integrate this into their day-to-day. It's also secure, because we've got to make sure that the information that we're collecting in here maintains that level of security. And you know, if we're going to provide clients access, we want to make sure that it remains secure. And we can also provide real-time monitoring in here for our lawyers and our legal teams. So I wanted to highlight real quick that Baker Donaldson and other firms have adopted processes like Baker Manage, but we're also seeing industry trade groups recognize the value of project management. The diagram that I've got displayed now is a model that the Corporate Legal Operations Consortium developed, and it follows a very similar process to what we're doing in Baker Manage. In 2017, CLOC decided that they needed a model that was sensitive to the needs of an in-house team. And so they assembled some professionals across the industry, including our firm, to help them evaluate what law firms were doing and develop an in-house unique model. And like, our approach, 4 phases: intake, planning, execution, and review. And the goal of this process is really for the legal department to produce quality legal work and achieving the goals and objectives of the business side of the corporation. The one big difference, and I've got it highlighted on this slide, between a law firm LPM model and an in-house LPM model is the intake phase that you see here. Intake for outside counsel involves triaging for business and ethical conflicts. Intake for in-house counsel is really to confirm that the request is appropriate for the legal department versus compliance or some other unit within the organization. It's about triaging the urgency of the matter, the risk profile, and the necessary expertise. So this is the one big distinction. I wanted to point that out between what law firms are doing in LPM and what the in-house teams are doing in LPM. And I just wanted to note, after developing this model, CLOC has actually produced a series of webinars that are available to the CLOC community that walk you through this process. There's a new initiative underway with CLOC right now that is actually building templates and resources to help in-house legal teams actually adopt and manage this process. So we don't have time to dive into all the elements of a legal project management model, but we wanted to take a minute to talk about 2 key elements. And the first is scoping your engagement. So most lawyers and some clients use generic engagement letters to confirm the terms of their engagement. And for a client that doesn't have legal training or experience, this engagement letter approach really lacks a good explanation of what they can expect and what may be required for the engagement. Even if the client has some level of sophistication, they may bring with them inherent assumptions about the engagement that they, from working with another law firm or from their own personal experience. And your engagement letter may not clarify some of those expectations and assumptions that they bring with them to the table. So we have found that providing a more detailed scope statement or statement of work will avoid confusion. It'll set the stage for a better estimate of the cost of the matter, as we're going to talk about on the next slide. And this detail also gives the client the ability to make decisions about what role they want their lawyer to play and what level of investment they want the law firm to make in that engagement. And the things to be included are shown on this slide. You want to provide a scope of the matter. And that identify the parties, the facts, the posture, the desired outcome, the task that you anticipate being provided. You also want to identify any assumptions that you're making in the engagement. And I've listed a couple of examples here for litigation and transactional. Also, if there's anything that's out of scope, this is very important to communicate. If you're carrying with you the assumption that typically you don't do this task or this component of an engagement, that needs to be communicated to the client so they can understand what they're getting. And this is especially true if you're trying to develop an estimate for the engagement. And what's key about this is I see this approach really helping us satisfy our ethical obligations. When teaching my first law school class on LPM, I was struggling with a way to help them understand, what are we trying to accomplish in this LPM model? And I had a eureka moment when I was looking at the ethical rules, because if you look at them closely, things like informed consent, competence, and scope, these are all articulated in a good scope statement. And especially to the extent you're limiting your services, the ethical rules encourage that be communicated in writing to the client.
David, can I ask a question? David, can I ask a question?
Absolutely.
If you'll go back to that slide, the first entry under there was talking about in the scope statement, the parties, the facts, the posture, the desired outcome or deliverables. And is that where we're talking about in this scope statement, get a very early understanding of what the best result for the client is, what they consider to be the critical success factors, so that we're all on the same page going in?
Absolutely. You're right on the money.
Okay.
And a lot of times, that this is almost like a checklist to go through too, Kyle. You may get that call about a new assignment and you're off to the races, but there's pieces of information that you really need in order to assemble a team and get things to, put in place to respond to the client's request and manage the engagement. So these are things that you should really confirm at the front end, and that outcome or deliverable, what is the client's strategy? Have they thought about that yet? Are they at that point? And understanding that so you know what level of support you're going to need for the engagement. So it's a great point. The second element I wanted to talk about very quickly is budgeting. So that scope process that we just went through is critical to being able to develop a good estimate. So, and one of the questions I get asked all the time is, what if my client doesn't ask for a budget? Why should I do it? And the reality is, even if they don't ask for it, they're going to start asking questions about it when they get that first bill. So we encourage our lawyers to be proactive in developing an estimate for the engagement, not only to help the client have a better understanding of what to expect, but also to help the team understand what to expect, because you want to put some parameters. Jennifer used the term guardrail earlier in the conversation. That's critical to help the team understand what they should be doing, what they shouldn't be doing, and developing a good estimate is critical. It also helps the client, form their strategy. If they're in litigation, understanding what the potential cost could be. If they're in a transaction, understanding what that could be. And so, these are some of the elements that we recommend in building out a budget. It should be consistent with the scope of work. If you can, look at historical matters to inform your estimate. Identify the team members that you're going to select to do the work. Don't do it haphazardly. Go ahead and design your team. Estimate that, what their level of contribution is going to be to the matter for different aspects of the case. And then, drawing upon your statement of work, build those assumptions and out of scope into your estimates so that you can communicate to the client what's included, what's not included. And then the biggest point is, don't put that budget in a drawer, manage to it. And we have found that, going through this process, and we call it intelligent budgeting, will produce a much better estimate of the engagement or of the matter than, most lawyers that I've worked with over the years. When they do this, when they work with us for the first time, they're picking a number that they recall from their last case, right? I handled a case like that a couple of years ago. This is my estimate. But when you sit them down and ask them to go through this process, it's amazing the difference that you see in the number once they go through the analysis. And just like scoping, a good budgeting approach will help you satisfy your ethical obligations. This is a reprint of ABA Model Rule 0.5, and some of the things in here. It helps the client understand the time and labor required. It may also help you clarify if you're dealing with unique issues. And it also, helps, the rule encourages providing a client with an estimate in writing. And so this helps you satisfy, those ethical obligations. So now that we've covered, yeah,
let me ask you
absolutely.
one other question about that. And I think I asked this of you before, but the way this is written, it's written in some respects like the budget that the client actually sees. And do you think that from the firm's standpoint, that the firm ought to have, what is this project going to cost for us to do the work? In other words, the cost of the resources that you're going to use. So you have your own budget that you need to look at and manage to as well. I mean, like if you have to bring in more and more resources, the cost of doing that work goes up. Are you following me? As well as what you're talking with the client about. Is it important from the firm's perspective to understand the cost of those resources? I guess is what I'm saying.
It absolutely is. And there's one key element here, most shareholders are higher cost resources, right? So when we're developing a budget, we're looking at the level of investment that we're making with shareholders and associates, and clients have expectations about how much shareholder time they want to see on their matters. They're getting charged more money for it. So going through this process will help the team design what's the right allocation of work on the engagement, and then using that to manage it and monitor it. And you'll see in a couple of slides I'm going to show you here in a second how we try to manage that and give our lawyers information so that they can make sure if you've set a leverage goal or the client has identified a leverage goal, let's make sure we maintain that throughout the course of the case. It's going to fluctuate some, but having a good budget will help you manage that instead of allowing it to naturally evolve. Does that answer your question, Colin?
Yes, it does. Thank you.
All right, so once you've got your budget in place, we require our teams to enter their time using phase and task codes that Jennifer referenced earlier. And then we use that time entry to reconcile against the original budget that we put in place. So this is an example of a reporting ledger that we use. It's a very simple automated report that can help the team. We can also open this up to the client so they can understand where legal spend is in real time. It may not be something that a client's going to look at daily or maybe even weekly, but what we've found is that for high risk cases where there's a lot at issue, where there's the potential for higher legal spend, clients want to see this budget ledger on a regular basis. They don't want to just see the bill every 30 days. They want to know maybe periodically, weekly or bi-weekly, what's the legal spend on that engagement. And I would say that if you're working on a contingency fee or a fixed fee, this same information is critical for you to see what kind of investment you're making in the case and what's the distribution of work on your team. Another tool that we've identified being very useful is something we call budget alerts. And this is a form that we use to set alerts inside Baker Donaldson. But think about it, if a lawyer's managing 20 cases in a week, they may not have time to go out and watch the budget ledger for every single one of those cases. So what we saw some challenges with that in the early days of implementation. So what we did was we set an alert up for budget thresholds to help the lawyers understand, okay, I'm reaching a threshold on this phase or this task of my case. I need to go look and see, what's going on. Maybe it's 50%, maybe it's 75%, so that they can judge, okay, if I've spent 50% of my budget on this task, is 50% of the work done? and making sure that, they're staying on track. And if they're not on track, either managing the team to get back on track or having a conversation with the client, giving them early warning that something could be occurring that may require some additional expense in the case. So I'm going to move from budgeting now to case management. And this is one of the things that Jennifer and her team, she was one of the early adopters of our Baker Manage approach. And through the experience working with her over, the past 7 years, Jennifer, we've really developed some improvements in our approach. So, think about a legal team that's managing cases. You got different lawyers doing different things across the firm. And each one of them probably has their own notepad. Each one of them has their own email archive. Each one of them may have probably a red rope that they keep of hard copies. So that file, that case management file, is spread all over the place with all the different timekeepers. So what we wanted to do was bring all that information together into a single repository through what we call a Baker Manage portal. And this is an example of the landing page. It's a typical landing page where we try to make information accessible related to that client. The site is available to our team internally and across the firm. Anybody who's working on the engagement can get access to that. If you're overseeing local counsel, which Jennifer had in her engagements, you can also let them interact with this type of system. And the value is that it provides greater visibility to the attorney and teams, helps them share information. And then if the client wants to come in and get access to that information, in addition to the legal spend, they can see it all here in one place. So on the landing page, what we've got is a very easy to see and use buttons that are quick links to things like the list of cases, summary of the updates, summary of key dates, form documentation. One of the things that this helps us facilitate is that if the client wants certain types of forms used in their engagement, we can make them available here. Also, if there's other types of resources that we want to make available, research, memorandums, expert lists, we can make that included here. One of the things that we also do on these sites, and Jennifer mentioned this earlier, is client guidelines. One of the things that we found is one of the biggest problems with write-offs is not complying with the client's billing guidelines. What happens is, in many cases, the matter comes into the firm, the guidelines are provided, and they go in a drawer. Nobody else sees them. So one of the things that we try to do with these sites is we try to make sure the entire team has access to the guidelines, and we even try to summarize those for the timekeepers who are doing the work in the trenches, so they understand what are some of the parameters that they need to operate in. And it helps us achieve better compliance with those client billing guidelines. So
David, is that portal available to everybody in the firm? I see you got a secure login. It's only available to the people that have been given the login access for that client or that case. Is that the way y'all handle the security issues? Right. That's
exactly right. Yep,
right,
absolutely. Right. So our team has access to these sites from a maintenance standpoint, but just the legal team that's managing that case has access. And then we can also provide secure access to clients so that they can log in, and we can also audience target who within the client organization sees certain things. So general counsel may see everything. Associate general counsel who's managing a certain bucket of cases, they may only see their cases in the system.
Good, thank you.
All right, I'm going to walk you quickly through a couple of examples here of different views that we have in the system. So at a matter assignment level, we're providing detailed information about the matter, data profiles, calendar dates, budget to actual spend, as well as matter updates. But we also recognize that clients may need more information than just legal spend and status updates, especially if they don't have their own matter management system. So what we try to do is we will customize and develop these systems to actually track unique things. So this is an example of a litigation portfolio where we've actually got all the matters classified by the stage that they're currently in. So you've got a list of all cases, you've got cases that are sitting in discovery, cases that are sitting in summary judgment, trial, and appeal. And what that makes it's very easy for the client to be able to navigate and look at those cases that are, on their critical list. This is an example, of another type of report where we are providing case management updates. One of the great values of a system like this is, you can have each attorney who's managing a case going in and updating their matter in the system. So when Jennifer's managing a portfolio, she doesn't have to email the team and say, all right, I need to know what's going on in your case. All she's got to do is go into the system, pull that case up, and she can see what the last update was. Now, in reality, we still have to do a little prodding to make sure people are putting their updates in this system. That should be totally transparent, but it's a much more efficient way to manage that process of case status updates. And then what it allows us to do, if the client wants a bi-weekly or a monthly report on the status of cases, we can actually automate that reporting in the system. If they don't want to log in, we can push them a report out of this system that gives them a quick update.
Hey, David, is one of the evaluative tools that you use with your associates and others, their sort of follow through on giving updates in a timely fashion? Is that something that y'all look at?
Oh yeah, absolutely.
The system only works to the extent, the system works, but you've got to have people's willingness and ability to put the information in, right?
That's absolutely, and Jennifer's going to hit on how to do that.
Okay.
Lessons learned over time. So, all right. Lastly, I wanted to talk about, when you're implementing a system like this, you've got the opportunity to collect additional data. And so, here's an example on the top of the data we're collecting on the matter exposure. We had a client that wanted us to be able to categorize their portfolio into the high risk, low risk, medium risk cases. Also in the bottom part of the screen, you can also have a view in the system that gives you the procedural deadlines and where a case sits in its life cycle. Very useful both for a managing attorney like Jennifer or a client to be able to see where the status of those cases is. So that's a quick overview of some of the process and the technology that we've implemented to help support litigation management. So I'm going to let Jennifer talk about how you go about using this type of system with a team in a portfolio. Jennifer.
Thank you, David. The first thing I want to start with is the people. I think it's really critical that you understand from the outset that to be successful, managing a portfolio using legal project management requires not only a really good process, but also people who are committed to the process. And the way to get people committed to the process is to have a good process. So it's kind of a chicken and an egg thing, but you do need lawyers who are experienced with both implementing and working within the framework of legal project management. We're proud at Baker Donaldson to have years of experience across multiple areas of practice working with these processes, and we're really proud of how well we succeeded with it. It's been a real game changer for us and for our practice and for our clients. So, as a way to demonstrate how a successful engagement can be when you bring together the right people and the right processes, we're going to take a look at a case study, the portfolio of national litigation managed by Baker Donaldson using Baker Manage. And this is an engagement that I personally managed working with David. First, we have a team of attorneys at all experience levels and price points. That's really important. When you're building the program, you need to make sure you're putting together a good toolbox. And the team members are one of those tools. You don't want a partner answering discovery, and you don't want a first year solely responsible for drafting a motion for summary judgment. So you need all experience levels so that you can set out your scope and budget properly based on the members on the team. A network of local counsel for jurisdictions outside of our footprint. We implemented this in this particular program so that would reduce the number of outside counsel that the company had to deal with. Initial case reports for all new matters. We prepare these, and these initial case reports are relatively short and to the point, but they outline the proposed scope of work or a case plan for every single matter that we get. And we also include a budget for all cases, which are submitted to the client for approval at the outset of the case. So we send it to the client, make sure they're on board with the scope, including the assumptions and what's out of scope, and that they've had an opportunity to see the budget. I will tell you that as a practical matter, we only budget to the summary judgment phase, and the clients are comfortable with that. They feel like once we get close enough to summary judgment, the case is more likely than not either going to settle or be resolved. And if not, then we head to the next phase of budgeting, which would be trial preparation and appeal. We use our budget builder program to prepare the budgets. And we incorporate both the national council, meaning Baker Donaldson's budget, along with the local council budgets. And this allows us to monitor, track, and adjust the budget as the case progresses. So the process that we set up, we had an intake process set up for all new cases, both on the client and on the Baker Donaldson side. So we met with the client and decided, what was the key information we needed from them when they sent us a case. What did they need to hear back from us and how? So we established an intake process for all new cases. We set up a portfolio site for all cases. And we had 3 different portfolio sites depending on the business unit involved in the litigation. Each matter has its own site that rolls up into the portfolio site. And then case notes, which David was speaking about a little while ago, this has become our client's particular favorite feature in the engagement. So we have case notes where attorneys and staff update the progress of the case, and they can attach key documents relating to that update to the case note itself. And as a practical matter, what they do a lot of the time is they just cut and paste the text of an email into there. If they've filed a summary judgment motion or whatever, and they're going to attach it, then they'll just cut and paste the email internally or to the client talking about that, along with the summary judgment motion. They'll put it in the case note. This particular client, more than wanting access to our Baker Managed site, wanted to be able to incorporate information from Baker Managed into their internal claims management platform. So what we do is these case notes that we were talking about, every 24 hours, they automatically transfer to the client's internal claims management system in their legal department. So every day they get the latest and newest of all of the case notes from the day before, and they roll up into their internal system so that they can scroll through all the previous case notes and know how the case has evolved and know what the most recent development is. They also get, if they choose to, not everybody in the legal department wants them, they get an automatic case note email alert. I get them for every case that we have in the engagement. And so every time somebody posts a case note, I get an email alert that has the content of the case note and a link to any of the documents that were attached to the case note. We have a master calendar for all cases, but one of the things that we developed a little ways into the engagement was the client didn't necessarily want to know everything that was on the master calendar, so they wanted a key dates calendar. So we developed 2 different calendars, one that literally has everything on it for every single case, and then a smaller calendar that rolls up what have already been designated key calendar dates, so that internally in-house counsel can know, okay, when do I have mediations coming up? When do I have dispositive motion deadlines coming up? How many trials do we have this year? Which cases are they in? And they can look at the key date calendar for that. We have a repository for frequently used documents such as protective orders and joint defense agreements and that sort of thing. We have the budget builder. We've used it to customize reports and alerts to the client regarding the status of the budget. And as they get those, we can review them and adjust them as necessary based on how the case has developed and whether or not the scope has changed. And we do it as a single report that has the budgets and the progress of the budgets, not only for just Baker Donaldson, but also for local counsel. So that's the process. So the people, and this is how we work within the legal project management program that we have. Within the firm, we have monthly meetings with everybody, all the key members of the team, not everybody who necessarily handles a case, but all of the key members of the team. We address necessary adjustments to the scope of the cases we're handling. We talk about staffing and budget and other issues, and we evaluate the process for ongoing improvement of the legal project management process. we do bill clients for this, and our client has been more than happy to pay it because it significantly reduces legal cost in the end, because it allows for more efficient management of cases. So if we're sitting in a meeting and it turns out that somebody is really sort of overwhelmed with their caseload and they still haven't gotten to that summary judgment motion, but it needs to be filed because we need to stay on task and move the case forward, we can shift it to someone else on the team. And we have an opportunity to talk about it, what needs to happen, and how, and you know, what's within the scope and what the plan is going to be for the person who's actually going to handle it once we shift that work. So it really allows us to reassess where we are on each of the cases, shift resources as we need to, and revisit whether or not the scope is still where it should be, and is the budget where it should be as well. Excuse me, we have developed witnesses and discovery responses, motions, agreements, etc., that can be used and customized as needed to specific cases and specific jurisdictions. We have management of local counsel to ensure compliance with scope of work and standardized processes and budgets. So our management, our day-to-day management of local counsel is handled by our paralegal, who just makes sure that they're checking all the boxes that they need to for the engagement. But we also reach out to them, the attorneys at Baker Donaldson who are assigned to monitor those cases, reach out regularly to local counsel and assist them with discovery and motions practice. We have, as a result of gathering data through the use of phase and task codes, we've developed phased AFAs for non-party witness and document subpoenas, which our client receives quite a few numbers of on a regular basis. So we've developed a really great process for that. It's become very cost effective for them to handle that third-party practice. Excuse me. We have quarterly meetings with the client. This is sort of how we do our evaluation process of where we are on the cases. We review all of the matters. We address any engagement issues, what is or is not working with them in within the process. We discuss how to improve the process to ensure ongoing efficiency and management of legal spend. We let them know if we're having issues dealing with witnesses or people within the business or whatever, or give suggestions about how we might be able to smooth the process to the benefit of everyone. And we help them identify institutional issues that will assist the legal department with its own process improvements for the department and for the company. So David, I think you're on mute.
Thank you. Thank you. Kind of following on what Jennifer just covered and the point she made about the reduction of cost, we wanted to talk a little bit about some analysis that we did in collaboration with the client to prove out, was this approach making a difference? So I think, Jennifer, we had been, partnering with the client for maybe, 3 years. And, we really wanted to look at the proof of the effectiveness of this type of approach. So we went to the client and, we had our data for what it was costing per matter for our approach, but we didn't have the historical information of what they had experienced before we took over this portfolio. So we went to the client and asked them, told them we'd like to do this comparison. And at the time, they basically told us that they were really busy and great idea, but we'll talk about it later. Unbeknownst to us, they went and did it on their own anyway, because I think they wanted to see what the impact was for themselves. And so using their data, what they were able to demonstrate was that over the course of the 3-year period since we had assumed responsibility for the engagement, they had seen a 45% reduction in the cost of their matters. And a data point that we hadn't really even thought of, and I got to credit Jennifer and her team with this data point, they had also seen a 65% reduction in the life of matters, of the engagement that Baker Donaldson was handling. Those are huge numbers. We didn't expect them. But this is a testament to how this type of approach can really have an impact on the cost of the client. This client, if you want to look it up, they were recognized as Legal Department of the Year for the implementation of this approach. And I think, Jennifer and I have talked about, how this how this engagement has evolved. And I'm gonna summarize it. Jennifer, please fill in any gaps. But essentially, we started out with project management, following every step to the letter, providing the client with scopes of work, estimates, that type of thing. And that built a level of trust and confidence in our ability to manage these cases effectively. The fact that we were using this project management technology system internally also gave them confidence. And so I think what we've seen now as the engagement has matured, they don't need to see as much because they trust that we're doing the job. They trust that we have processes in place. And so, and it's also created, I think, a much stronger relationship with this client. I think that, they would be hard pressed to go to another firm at this point because of the fact that they get so much value out of this approach.
Hey, David, can I go back to that slide there just a second?
Sure.
And the 65% reduction in the life of the matter, I have seen in-house people evaluate that a lot. And what it may speak to, if I'm understanding correctly, is the collaboration in setting the scope, developing the plan, and executing to the plan has led to better decision and the ability to share information on an ongoing basis regularly and easy access to it has led to better decision making earlier in cases. So they don't last as long. Better decision making.
Jennifer, you want to speak to that one?
Well, and the other thing that I will add, and anybody who's on this webinar who's in-house counsel can appreciate this, that was a number that they were almost more excited about than the cost of matter reduction, because the ability to reduce the life of the matter helps them so much with their indemnity and reserve obligations and their accounting and budgeting, the whole financial side of managing litigation at the company. The sooner you can get a case resolved, the better it is for them on their books, setting out what their risk is and what their retention requirements are for liabilities going forward and so forth. So that was one that I don't think we knew it was going to happen. We didn't know that it would be that impactful. And so it's something that really makes an impact with in-house counsel.
All right, so I wanted to spend a little bit of time here at the end talking about the data aspect of this whole process. And, we just got done talking about, how powerful that data story was to show what the impact of this type of approach is. But there's other reasons, other benefits that you can get out of using this type of approach to collect more data from your team on what you're seeing in these cases. Most firms have a intake system that really heavily profiles a matter once it comes in the door. But after that, it's all about time entry. It's all about billing. There's not a whole lot of additional data that's captured on a consistent and organized basis. A lot of it's unstructured, so you can't really analyze it as effectively to set strategy. So one of the things that we recognized after working with Jennifer and several other engagements is that you can really enhance the value to the team and the client of a system like this if you're designing it on the front end. Jennifer talked about the intake process, designing what information we need for intake, what information is going to help us throughout the management of the project. We're also looking at, the workflows of the team. What data points can we capture along the way? We're syncing up time entry with our project management system. Those two can't be separated. You need to be able to tie the amount of time it's taking to do certain things to your project management system, and then providing enhanced visualization so that you can look at trends that are happening. And we talked about this concept of simplicity earlier. You've got to make this easy for the team to engage with. You can't overcomplicate it. Some of the early project management tools that were coming out by different vendors, I think in 2012 through 14, were overly complicated. No attorney was going to be able to interact with that solution. So you've really got to have something that they're going to be able to interact with. Make it simple, make it less time consuming for them. And so this is a process that we've come through. I'm just going to hit on it very quickly and then show you a couple of examples. You know, Jennifer talked about this consistent process for managing your matters. Use that process to identify what data you want to capture along the way and using it for the things I've got listed here on the slide. The types of data that you can capture and use are things like, you know, of course, you've got cost and your budgets, but also what kinds of outcomes are you seeing? Settlement compared to your cost, what's your staffing mix? We talked about that a little bit ago, Kyle. And then, you know, what other professionals are being engaged on these? Also, you know, a big critical element for clients is responsiveness. What kind of responsiveness are we seeing? And then, as we showed a minute ago, looking at the cost per matter and the duration of matter. And then, you know, if you're going to capture this information, share it with the client. One of the things that Jennifer helped us realize is these quarterly meetings are a great way to facilitate sharing what you're capturing with the client, collaborating on evaluating trends. So I've got a couple of slides here I want to show you of what kind of enhanced data capture can do. So one of the emerging uses of data that we're seeing is evaluating a firm's commitment to diversity inclusion. And so for staffing matters, we have a number of clients who have identified goals and they want regular reporting to see if we're meeting those goals. Baker Donaldson has also established, you know, its own goals for diversity and inclusion in a D&I compact, which we've adopted, which also sets goals that we want to achieve as far as leadership, shareholder placement, and staffing. So the old adage of you can't manage what you can't measure holds true. And so we wanted to provide our lawyers with reporting that will help them analyze how they're doing against these diversity and inclusion goals. So on the left side of the graph, we're tracking the distribution of timekeepers from one year to the next as to headcount and hours. In the middle, we're tracking the classifications of diverse timekeepers who are being utilized on the client matters. And on the right side, we're specifically looking at females and the timekeepers and how they are being utilized on engagement. So this type of report really helps you manage to the goals that we talked about. This is another example of how data can be used. It's a very limited set of data, but it really can tell some great stories. And it can be, you know, when you start capturing additional data points such as settlement, you know, closure and why it's closed, is it dismissal, default judgments, motion for summary judgment, and comparing that to your matter counts and hours, you can really start to see some trends revealed. So in the top chart, you know, we're showing matters within the portfolio that have settled over time. We also track settlement values, which are not shown on this slide. But in this example, you can see that a large number of cases are reaching settlement, with the largest numbers coming within 180 days of filing. There's also a number of cases being resolved or closed without settlement, with the larger number of those occurring within 180 days. So this actually tracks that movement and activity on those cases, making sure they're getting resolved. In the bottom chart, you can compare hours invested to cases settling, closed, and remaining open. And as you would expect, the investment of time is greater for those cases that are settling early in the life of the case versus later. You know, this type of information can really be used to help manage the team, help the client set strategy, request adjustments, really can provide some value to the engagement. So I'm going to turn it over to Jennifer to talk about our conclusions from all this.
So to summarize, I think, you know, as we said at the beginning, everybody is familiar with the historical controls that have been imposed on litigation and how ineffective they have been because they presume primarily that law firms are incapable of efficiency. But with legal project management, process and people can come together to achieve better litigation management that really moves the needle on legal expense. It requires attorneys with experience managing large case portfolios, and a process and excellent technology that provide the support to that team that is essential to a successful engagement. And finally, designing the process for improved data capture so that you can empower legal teams and clients to continue to innovate ways to control costs and more quickly identify strategic opportunities.
All right. Well, we greatly
Wonderful.
appreciate the opportunity to speak with you all today. Do we have time for questions, Kyle?
I have one question that came up, and then I'm going to close us out, and that is, does your matter management platform have API integration with any of the outside vendor platforms and services?
Yeah. So one of the big ones is time entry. So we use Aderant, and we have a sync with Aderant in our system so that we can bring in that time data. There's also other firm systems, data within the firm that we're bringing into this. You know, NBI, we have a new business intake platform. There's data in there that we don't want to ask people to duplicate in our platform, so we're pulling that over. So yes, it really depends on the data source. And yep.
Good. All right, we've hit the end of the hour, and I just want to tell you, David and Jennifer, I thank y'all so much. It's superb. It fascinates me every time I visit with y'all about how much more I learn about project management and bringing project management to litigation. I cannot thank y'all enough for your willingness to join with us in this desire that everybody implement LPM. And I'm gonna tell you, from those of you that are listening, your clients, and I don't care whether you're a plaintiff or your defense, litigation project management, bringing those project management principles to the work that you're doing in litigation is essential. And it's going to be demanded, and it's going to be essential to be cost effective into the future, no matter where you are and what you're doing in handling litigation. And good people like David and Jennifer have been at the forefront of this effort to get people to use project management. If you want to learn more about it, obviously you can go to the website for Baylor Law LLM and litigation management and look at what we do from our R6 format. And we'd love for you to do so and join our program to learn more as well. I will tell you also, in the chat feature, you will see the CLE number for this particular webinar. And with that, I just thank everybody for attending. David, Jennifer, thank y'all again for so much for just doing this and taking the time and being a friend of our program. Greatly appreciate you.
Thank you for having us.
Thank you, everybody. Have a great day.
You too. Thanks.